Iowa District Court is now in session. The Honorable Andrew Chappell presiding.
Please be seated. We are on the record in case number FECR 009101, State of Iowa versus Nathan Russell. This matter is scheduled for a combined plea and sentencing hearing at this time. I'm Judge Chappell. The state appears by Jones County Attorney Christopher Lyons and Assistant Jones County Attorney Sarah Smith. Defendant appears in person with his attorneys Douglas Davis, Kedra Tucker, and Adrian Houghton. The court has been informed that the defendant is appearing for the purpose of requesting permission to withdraw his previously entered plea of not guilty. Is that correct, Mr. Davis?
Yes, it is, Your Honor.
And Mr. Lyons, is there a plea agreement?
There is, Your Honor.
What is the plea agreement?
Your Honor, the plea agreement is as follows. The defendant will plead guilty to count 1, murder in the first degree, in violation of the code section set forth in the trial information. The defendant will admit guilt and will not seek an offered plea. The defendant will supply a factual basis in open court, subject to reasonable inquiry by the state. The defendant will further agree that the court may rely on the minutes of testimony to find a factual basis. The defendant will be committed to the custody of the Department of Corrections, the Director of the Department of Corrections for the rest of his life. He'll be ordered to pay pecuniary damages in an amount not less than $150,000. He will pay all applicable surcharges and civil penalties. The state will recommend the fine be suspended on counts that carry suspendable fines. The defendant will pay court costs, including for dismissed charges. The state will dismiss all remaining counts under the case 31 days after sentencing if the defendant does not appeal or otherwise challenge his guilty plea. The state will agree to return back to the defendant's custody both the currency and the watches that were in his possession at the time of his arrest. We will arrange with Mr. Davis to do that after today's hearing. Further, the Jones County Attorney's Office will agree that they will not seek further prosecution of any currently known information related to the defendant's cell phone that was taken from him at the time of his arrest, and any related potential evidence on his laptop that was obtained later via a search warrant. Thank you.
Mr. Davis, were you able to follow Mr. Lyons' recitation of the plea agreement?
Yes, I was, Your Honor.
Is that consistent with your understanding of the agreement?
Yes, it is, Your Honor, and after conferring with Mr. Russell and having him evaluated as well, and against our advice of counsel, it is his desire to enter a guilty plea. The only addition I can say to the agreement is that, or let the court know that we will be filing Category B restitution as well.
You the financial affidavit?
Yes.
All right. Mr. Russell, were you able to follow the plea agreement that was set out?
Yes, Your Honor.
And is that at least preliminarily something that you've authorized Mr. Davis to enter into on your behalf?
Yes.
Okay. The plea agreement has now been stated on the record. Mr. Russell, before I ask you how you wish to plead, I have to make sure you understand the crime to which you're proposing to plead guilty, the consequences of pleading guilty, and the rights you give up by pleading guilty. I want to make sure you understand everything that I'm saying today and the significance of your responses. You obviously have counsel here today. If you need to confer with your attorney at some point, just let me know. If you have a question, just let me know. I'll try to answer it, or we can have your attorneys try to answer it. If you need me to repeat something, just ask. I want to make sure that when you leave here today, you've understood everything that's gone on and the consequences of everything that we have done. Will you do that for me?
Yes, Your Honor.
The crime to which you are proposing to plead guilty is murder in the first degree in violation of Iowa Code Section 707.1 and 707.21a. This crime is a Class A felony in Iowa. That means that if you are convicted of the offense, the maximum penalty is life in prison with no possibility of parole. There is no fine and there are no surcharges associated with this charge. You would be assessed court costs and other applicable miscellaneous fees as well as restitution. That restitution would include, in part, a requirement that you pay $150,000 to the estate of the person who died as a result of the crime. You also would be required to give a sample of your DNA for profiling purposes. The minimum sentence is the same. Counsel, have I correctly stated the maximum and minimums for the offense?
Yes, Your Honor.
You agree, Mr. Davis?
Yes, I do, Your Honor.
Do you understand so far, Mr. Russell?
Yes, Your Honor.
If this matter were to proceed to trial, the state would have to prove by competent evidence beyond a reasonable doubt and to the satisfaction of a unanimous 12-person jury or the court if the case were tried to the court the following elements. On or about November 7th, 2023, while in Jones County, Iowa, you shot Aaron McAtee. Aaron McAtee died as a result of being shot. You acted with malice aforethought. You acted willfully, deliberately, premeditatedly, and with the specific intent to kill Aaron McAtee. Counsel, have I correctly stated the elements of the offense?
Yes, Your Honor.
Yes, Your Honor.
Mr. Davis, do I need to explain the concepts of malice, aforethought, and deliberation?
Previously to going on the record, Your Honor, we have conferred with Mr. Russell what those terms meant, but I think for a clear record, we should probably have you do so.
I'm happy to do so, counsel. Under Iowa law, Mr. Russell, malice is considered a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from your acts and conduct and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another, which exists before the act is committed. It does not have to exist for any particular length of time. Willful means intentional or by a fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. And to premeditate is to think or ponder upon a matter before acting. Deliberation and premeditation need not have existed for any particular length of time before the shooting. Counsel, is that adequate explanation?
Yes, it is, Your Honor.
You agree, Ms. Smith?
I do, Your Honor.
Okay. Mr. Russell, do you understand what I've said so far?
Yes, Your Honor.
How old are you, sir?
39 years old,
What is the extent of your formal education?
some college.
Do you have any difficulty reading, writing, or understanding English?
No,
Are you presently under the care of a doctor, psychiatrist, psychologist, or counselor for any condition?
no,
Are you currently under the influence of alcohol, drugs, or medications of any
No.
kind? Please let me finish.
oh, sorry.
Sorry. So no alcohol, no drugs, no medications of any kind at this point.
No,
Are you presently on probation or parole for any criminal convictions in any state or federal court?
no,
Do you have any other charges that you know about pending against you at this time in any court anywhere?
no,
Mr. Russell, you have some options available to you today. First, you still may plead guilty if you wish to do so. If you wish to plead guilty, I can only accept that plea if I know that you are making it knowingly, intelligently, and voluntarily. Second, you may decide to continue with your current plea of not guilty. At this point, you still have every right to continue with that not guilty plea. Third, if for some reason you contend you've already faced this charge in another case, and you were convicted or acquitted, you also may plead what's called the defense by a formal acquittal or conviction. Do you understand you have those options?
yes,
Have you discussed those options with your attorneys?
yes, Your Honor.
Are you either a United States citizen, or if not, have you and your attorneys discussed what consequences pleading guilty today could have on your immigration status?
Yes,
If you enter a plea of guilty to this offense, you will be giving up or waiving a number of rights that are guaranteed to you by the Iowa and United States Constitutions and Iowa law. I want to go over them with you and make sure you have a chance to ask questions about them. If you plead guilty today, you will give up the following. You'll give up your right to a speedy and public trial. You'd give up your right to a jury trial, or if you prefer, a trial to the court. You give up your right to have a competent lawyer defend you before, during, and after the trial, and if you cannot afford to hire an attorney, to have an attorney provided for you at public expense, just like the attorneys you have now. You would give up your right to confront all of the witnesses on whose testimony the state will rely in attempting to convict you. You will also give up or waive your right to cross-examine each and every one of those witnesses. You would give up or waive your right to present witnesses on your own behalf at the time of trial. You will give up or waive your right to compulsory process in securing the attendance of those witnesses at trial. That means if there were witnesses you wanted to present in your defense and they refused to appear voluntarily, to testify, the judge at your request would issue subpoenas to require them to come to trial and testify. This would enable you to present their testimony on your behalf. You will also give up or waive your right to be presumed innocent. You are, of course, presumed to be innocent until such time, if ever, as the state establishes your guilt with competent evidence beyond a reasonable doubt to the satisfaction of a unanimous 12-person jury or the court if the case is tried to the court. Finally, you will waive or give up your privilege against self-incrimination. That is, at no time would you have to take the stand and testify under oath. That is a decision only you would make, and only after having a chance to discuss it with your lawyers. You have the right to testify at trial, but no one can make you testify because you have the right to remain silent at trial. If you chose not to testify, the judge would not let the state's attorney comment on the fact that you did not testify, and the jury would be instructed that it could not infer anything against you from the fact that you did not testify. If you plead guilty today, you will be waiving all of those trial rights that you have. Do you have any questions about any of those rights?
No, I don't.
Do you understand, Mr. Russell, that you will be giving up or waiving all of those rights if you plead guilty?
Yes, Your Honor.
If you plead guilty, you will have to make victim restitution for court cost, and restitution for court-appointed counsel fees if your attorneys are appointed. Do you understand that?
Yes, Your Honor.
Are you satisfied with the advice and services that have been provided to you by your attorneys, Mr. Davis, Ms. Tucker, and Mr. Houghton?
Absolutely, yes.
Other than the plea agreement, has anyone made any promises of any kind or any threats of any kind to you, your family, or anyone else to try to get you to plead guilty today or otherwise influence your decision?
No, Your Honor.
I told you earlier in the hearing what the maximum and minimum penalties for the offense are. They're the same in this particular case. In most cases, I would ask if anyone had told you the specific sentence you would get, as opposed to what would be recommended to the court. But for this particular offense, there is no discretion. The sentence is mandatory. Have you had enough time to talk to your attorneys about this case and about your plea here today?
Yes, Your Honor.
All right, Mr. Russell. How do you wish to plead to the crime of murder in the first degree in violation of Iowa Code Sections 707.1 and 707.21a?
Guilty, Your Honor.
Mr. Russell, have you read the minutes of testimony that accompanied the trial information? That is, the list of witnesses and what they allegedly will say.
Yes, Your Honor.
You've read that document?
Yeah. Yes.
Are those minutes of testimony substantially, factually correct?
Yes, Your Honor.
Mr. Russell, I can only accept your guilty plea if I find there's a factual basis for doing so. Would you please tell me in your own words what you did to commit murder in the first degree?
I had an AR-15 in my car, and I shot Aaron McAtee.
Did Mr. McAtee die as a result of you shooting him?
Yes, he did.
Just to be clear, an AR-15 is a firearm? Yes?
Yes.
Did this event occur on or about November 7th of 2023?
Yes, Your Honor.
And did this event happen, the shooting happen in Monticello, Jones County, Iowa?
Yes, Your Honor.
When you shot him, Did you do so willfully, deliberately, and with premeditation and malice aforethought?
Yes, Your Honor.
Ms. Smith, do you believe the record establishes a factual basis for the offense of murder in the first degree?
Yes, Your Honor.
Mr. Davis?
Yes, Your Honor.
The court agrees and finds that defendant's plea of guilty is voluntarily and intelligently entered, excuse me, and done so with an understanding of the charge, knowledge of the criminal consequences of the plea, knowledge of the statutory and constitutional rights waived by the plea, and that there is a sufficient factual basis to support the plea. The defendant's plea of guilty to the offense of murder in the first degree in violation of Iowa Code Sections 707.1 and 707.21a is accepted and hereby entered of record. Mr. Davis, does your client still wish to proceed to sentencing in this matter?
Yes, he does, Your Honor.
Mr. Russell, normally any challenge that you would wish to make to your guilty plea based on any alleged defects in the proceeding, any mistakes that you think I might have made, would have to be raised in what is called a motion in arrest of judgment. A failure to raise those challenges would preclude you from your right to assert them on appeal to the Iowa Supreme Court. A motion in arrest of judgment must be made no later than 5 days before the date normally scheduled for sentence, and no more than 45 days from the date of your guilty plea. You're also entitled to a delay in sentencing. You have pled guilty to a Class A felony, so you do not have the right for the court to have access to a pre-sentence investigation report prior to sentencing. But in any event, because you have asked for immediate sentencing, you will not be able to file a motion in arrest of judgment. You'll waive that right, and you will also be waiving your right to have the sentencing delayed. Have you discussed those things with your attorneys?
Yes, Your Honor.
Having discussed those, do you still wish to proceed with sentencing at this time?
Yes.
All right, defendant has just pled guilty to the offense of murder in the first degree in violation of Iowa Code Sections 707.1 and 707.21a. That being the case, is there any legal cause to be shown why judgment in the sentence should not now be had?
No, Your Honor.
No, Your Honor.
You agree, Mr. Russell?
Yeah.
Then we will proceed. The plea agreement has already been recited. Defendant has pled guilty, as I noted, to murder in the first degree. I have not reviewed a pre-sentence investigation or report because pursuant to Iowa Code Section 901.22a, none is ordered in a case like this. Ms. Smith, are there victims that wish to be heard in this matter?
Yes, Your Honor. The state has already filed copies of letters written by members of Mr. McAtee's family. Becky McAtee, Dan McAtee, and Matt McAtee have all written statements and wish for the victim advocate, Penny Galvin, to read that aloud for the court today. And then Mr. McAtee's sister, Amy Juwan, wishes to read her own statement.
And we'll get to those, but could you spell the name of the victim advocate?
Penny, Penny, Galvin, Galvin.
Thank you. Will we hear from the victims last? Does the state wish to be heard with regard to sentencing?
Yes, Your Honor, thank you. Your Honor, the actions of Nathan Russell on and leading up to 7:24 a.m. on November 7th, 2023, have likely forever changed the community of Monticello, Iowa. The thought that an average, everyday citizen going about their normal daily routine could be senselessly gunned down in broad daylight for no apparent reason shocks the conscience and stripped away an entire community's sense of security and safety. Aaron McAtee was, by all accounts, a remarkable citizen within his community, beloved by family, friends, co-workers, customers of the Fairway store where he worked, and the community as a whole. Those that loved him have suffered an unimaginable loss, and they will forever be left questioning how something like this happens and why it happened to Aaron. His wife and their 3 boys will have to struggle with the utter sense of unfairness this situation leaves behind. Not to be overlooked are the law enforcement officers that tried to save Aaron and those that were forced to search for and apprehend this killer. Thankfully, the quick reactions and coordinated efforts of all of our local Jones County law enforcement agencies led to the quick identification of the defendant as the perpetrator of this senseless and heinous crime. The bravery and heroic efforts of the Delaware County deputy that apprehended the defendant before he could kill again cannot be overstated. And the invaluable assistance of the Iowa Division of Criminal Investigation, led by Special Agent Dustin Henningsen, working closely with Monticello Police Chief Britt Smith, and helping to coordinate the efforts to put all of the pieces together, created a solid case, leaving no doubt that Nathan Russell was the man responsible for this crime against not only Aaron, but his community as a whole. The state is asking the court to commit Nathan Russell into the custody of the director of the Iowa Department of Corrections for the rest of his life without the possibility of parole, as required by Iowa Code Section 902.1. The state is requesting the court order the defendant to pay at least $150,000 to the estate or heirs at law of Aaron McAtee, as required by Iowa Code Section 910.3b. The state has filed a preliminary statement of pecuniary damages, but is requesting an additional 30 days in which to submit a finalized statement. No punishment for Nathan Russell will bring back Aaron McAtee. No punishment for Nathan Russell will be able to erase this tragedy from the collective memory of the citizens of Jones County, and in particular Monticello. No punishment will restore the feeling of security and safety from living in a close-knit, small town that was destroyed when Nathan Russell stalked the streets of Monticello, armed with an AR-15 style rifle, and indiscriminately picked a target at random as the citizens got ready for their day and their children walked to school. However, Nathan Russell, by his own actions, has forfeited the right to enjoy life as a free man, and now he must pay the price by spending the rest of his natural life in prison. Hopefully the family, the friends, and the community of Aaron McAtee can now find a bit of closure and begin the process of healing.
Thank you, counsel. Mr. Davis, does the defense wish to be heard with regard to sentencing?
Yes, Your Honor, thank you. Since the inception of this matter, I have gotten to know Nathan better and better each time I visit with him. And each time he feels more remorse and is sorry for what he has done and the pain that he has inflicted not only on the community but more importantly the family and friends of Aaron. He has taken responsibility, Your Honor, by pleading guilty. He accepts his punishment. He knows well that he will be in prison for the rest of his life. And unfortunately, there's nothing he can do to change the events that occurred last fall. But he certainly does feel a great deal of remorse and sorrow. And every time, as I say, I've met with him or spoken with him, he has always expressed that and the pain that he felt in inflicting that on others. And he knows that no matter what, he can never bring Aaron back, but hopes that someday they will forgive him for what he has done, and that he certainly is going to pay his debt to society and to the family, more importantly, as to what occurred.
Thank you, counsel. Mr. Russell, Iowa law requires me to give you an opportunity to address me directly before I render judgment in this matter. Is there anything you would like to say at this time?
No, Your Honor.
This time we'll hear the victim statements.
Your Honor, first is the
May I put my microphone right up here?
I'm reading this victim impact statement on behalf of Matt McAtee, Aaron's brother. When you took my brother Aaron's life, you robbed him of a good death. My brother has always been surrounded by the love and support of family and friends. You, however, will be alone behind bars with no family or friends to say goodbye to you. No one will be at your funeral, unlike the hundreds that were at Aaron's funeral. You're a nobody. Sometime in your life, you will come to realize how you screwed your life up. When you come to that realization, do something productive with the time that you have left. Get and stay sober. Be a mentor and help other inmates become better people, especially those who will have a chance to have a life outside of prison. My brother was a mentor and a friend to many people in this community. If you do anything in prison to better yourself and others, then maybe you will have a friend or two at your funeral. No matter what you do with your life in prison, no one on the outside will care. I will never care. Aaron's friends and extended family will never care. We will not even care how or when you die. We will never forgive you. You are alone and you are a coward. You will die alone if you continue on your current path. It's a shame that you're allowed any possessions in prison, but at least you will be getting what you deserve with life in prison. Your possessions really should be going to Aaron's wife and children for not allowing them to grow old with Aaron. You should go to prison with nothing, so you cannot buy friends. You will die alone in prison. You will never have a good death. Good riddance. Matt McAtee, Aaron's brother. The next one I'm reading is on behalf of Dan McAtee, Aaron's father. Our son, the hero. It is my belief that unknowingly, Aaron may have saved a lot of lives in Monticello. We have heard that the murderer was driving by schools, factories, and Camp Courageous. We know Aaron that he would rather have had taken a bullet than anyone in town. It could not have been more devastating. You'll always be our hero. Love you, Mom and Dad. The last one is on behalf of Becky McAtee, Aaron's mom. Our family's had a great loss by what you have done. I'm not going to try and understand why. Our son was a family man, dedicated to his family, work, and community. He had a big, loud laugh and voice. Whenever he was around, we would notice him by his voice. He could put a smile on your face even when you didn't feel like it. Our son would welcome new people to the community by shaking their hands and asking them about their day. Not a person was avoided. We have been told many times how people were warmed by his quick wit and remarks. The positive impact was always there. He knew the meaning of a team and how working together was the best way to handle a situation. As a coach, not all kids are stars, but he knew that. He would take the time to work one-on-one to help kids grow to be their best. Encouragement, not discouragement. If they messed up, he would take them to the side and tell them if it happened next time, they would know what to do. Family was always first. He was thinking about providing for his family each day. Providing can be in so many ways. Loving and comforting is only a small part of it. He was able to not give only what his family needed, but to be tough as a man when it was needed. No family is perfect, no community is perfect, but he would try to provide that protection to his family. The impact on this has left an emptiness in our hearts. The family was devastated and still is. Each of his sons has stepped up to be in our son's shoes. He impacted his sons to work hard and earn respect for a job well done and to not disregard others. His wife was stunned not being able to smile for months. She was afraid to be in the same house, moving away from the dream house they so much loved. So many responsibilities were on her alone. We reached out to help, but always the sadness was apparent. Yes, our son touched many lives, but he would have been the first person to welcome you, holding out his hand and asking how your day was. Your choice was not a good one. That day by shooting our son, you impacted many negatively. Whether you hear this or not, you missed out on someone who could have had a great impact on your life and pointed you in a direction that could have benefited you. We will never be able to hear his laugh, or his booming voice again, nor will you. Becky McAtee, Aaron's mom.
All right, watch your step when you have a seat.
Whenever you're ready, Mr. Ron.
Okay.
We are here today because of your actions. Everything is because of the choices you made on Tuesday, November 7th, 2023. My family's lives have been turned upside down. Our hearts and our minds are a mess. I wake up every day and think about Aaron. The sadness I feel is unreal, and I find myself going numb a lot. I can't wrap my mind around the fact that he's gone. It hurts too much to think about it, so my mind turns off.
Take your time.
The day Aaron was killed was my youngest son's 18th birthday. That morning, I made a post on Facebook about him and wrote out a card to him. It was going to be a good day, a day when my child became an adult. We never could have imagined what was going to happen to all our lives. What a cruel way to welcome him into adulthood. Every year going forward, his birthday will have this shadowing over it now. This horrible event has messed up how I look at others and situations. The first few weeks, my body would shake when I tried to go into any store. Still today, family events always end with tears on the drive home. This July, we were supposed to do a family trip. Aaron and I were planning it. I had hoped to surprise him and the rest of my family with a visit from my high school exchange student. My heart can't even think about something fun like that anymore. My happiness is at a standstill. I used to be a silly and goofy person. Now people tend to avoid me or talk a lot less to me. My mind is fuzzy and I have a horrible time focusing. My job is now a struggle to keep my mind on task. I used to crank through my work, but have slowed down greatly. I'm extremely tired every day and have no motivation. I have little feelings right now besides sadness. I feel indifferent when it comes to you. I should feel anger and hate towards you, but I feel like I don't care about you at all. I hate feeling numb. I want to get mad and scream. I want to feel like I did before. Life is not perfect, but at least I felt alive. I feel like I died with Aaron that day. All I want from this is for you to be gone and locked up for good. You're a grown man and had many opportunities to make yourself a better person. Maybe now you will choose to stay clean and become someone your family can care about again. You'll never be half the man Aaron was, though. He made me proud to be his sister. We argued and competed nonstop, but I loved him so much. I'll never get to share another birthday, vacation, or holiday with my younger brother. I was looking forward to yelling and cheering with him at his youngest son's sporting events. I was looking forward to growing old with him and having more vacations together. It's all gone now. All I have is memories, and my heart is broken for good.
Yes, Your Honor.
The defendant is now hereby adjudicated to be guilty of Class A offense, murder in the first degree, the violation of Iowa Code Sections 707.1 and 707.21A. Judgment is hereby entered accordingly. In sentencing the defendant, my decision must be based on numerous things. I must consider what sentence will give the defendant the maximum opportunity for rehabilitation. Rehabilitation from a crime like this is often difficult to predict. The best is that the sentence, if nothing else, creates time so that hopefully there can be some rehabilitation. I'm required to consider what sentence will provide protection for the community from further offenses by the defendant. This is a primary concern in this case. Gun violence in general, but random gun violence of all things. To people unknown, the public requires protection from that. I considered the nature of the offense and the underlying facts. This was indeed a heinous and senseless crime. It was completely unnecessary, completely unjustified. You took something that wasn't yours to take, and nothing you do now can return that. You ended Aaron McAtee's life and significantly altered the lives of his family and very likely the community as a whole. And to Aaron's family, I express my deepest condolences. The court has little information about your prior record of convictions because that hasn't been provided to me. I don't have a pre-sentence investigation report. I have little information regarding your age and education and employment other than what we've discussed here today. As I indicated, no pre-sentence investigation was ordered. I'm required to consider the fact that restitution is ordered, and the statutory restitution will be ordered. I've considered the very impactful victim impact statements. I find that victims are often much better able to put words to a weighty situation like this than I ever would be. I've considered the recommendations made by the state, and last but certainly not least, I've considered the fact that first-degree murder carries with it a mandatory sentence, and that when sentencing an adult for this crime, I have no discretion to deviate from the sentence the Iowa Code provides for it. Considering all of those things, I enter the following sentence for the defendant. The Class A felony offense of murder in the first degree in violation of Iowa Code Section 707.1 and 707.21a, defendant is hereby sentenced to be confined to prison for the remainder of his life with no possibility of parole. Defendant is to be given credit for any time previously served. Defendant's custody is hereby placed with the Director of the Iowa Department of Corrections with his temporary custody with the Jones County Sheriff. Defendant is not sentenced to pay any fines or statutory surcharges because there are none that are associated with this crime. The defendant is ordered to pay victim restitution in the amount set forth in any statement of pecuniary damages previously filed or to be filed by the state within 30 days from today's date. Pursuant to Iowa Code Section 910.3b sub 1, defendant also is ordered to pay restitution in the amount of $150,000 to the Aaron McAtee estate, or if no estate has been opened, to his heirs at law. Defendant also is assessed restitution for court costs in the amount established by the clerk of court, as well as the cost of court-appointed counsel fees. Defendant may request a hearing on his reasonable ability to pay any Category B restitution, and if he submits the appropriate financial affidavit, the matter will be set for hearing unless the state agrees defendant lacks the reasonable ability to pay the Category B restitution or waives hearing on the matter. Pursuant to Iowa Code Chapter 81, defendant will provide a DNA sample for DNA profiling to the Iowa Department of Correctional Services. Defendant's prior bail provisions are exonerated. No appeal bond is set because defendant is non-bondable pursuant to Iowa Code Section 811.1. Mr. Russell, you do have the right to appeal this case to the Iowa Supreme Court. If you're unable to pay the cost of the appeal, you have the right to apply to this court
for the appointment of counsel and the furnishing of a transcript of the proceedings, all is provided for in Iowa Code Chapter 814. In order to perfect your appeal, you must file a written notice of appeal with the clerk of the district court within 30 days from today's date. Perfecting your appeal in this manner is jurisdictional. It means a failure to file that notice would preclude you from being able to appeal. If you do appeal, you have to have a copy of that notice of appeal served on or delivered to the Iowa Attorney General. All sums ordered paid are due and payable on this date. I normally would dismiss counts 2 and 3. Given the recitation of the plea agreement, the court will await the motion to dismiss to be filed, I believe 31 days from today's date to dismiss those counts. Mr. Lyons, Ms. Smith, have I missed anything? Is there any further record you believe we need to make?
I don't believe you've missed anything, Your Honor.
Mr. Davis, same question.
Nothing that I believe, Your Honor.
I don't imagine, while this proceeding may provide some closure to the community, I don't imagine it will provide much solace. And I hope over time you're able to find that. At this point, we're adjourned.
Thank you, Your Honor.
Thank you, Your Honor. I assume you're going right home. He's with